Now turn to the next case on this morning's docket. That is case number 103158, State of Kansas v. Terry G. Mishmash.
Good morning, Your Honors. May it please the Court, Lydia Krebs, Capital Appellate Defender Office for the appellant, Mr. Terry Mishmash. And if I may, Your Honor, I would like to reserve 3 minutes for rebuttal, please.
3 minutes is granted.
Thank you. Unless the Court would prefer otherwise, I would like to submit Issue 1 on the brief and instead focus solely on Issue 2, which is the argument that the District Court erred in ordering Terry to register as a drug offender under KSA 22-4902, subsection 11A. Because this issue is one of statutory interpretation, this court does have unlimited review. In State v. Horn, this court explicitly recognized that its holding, which again involved the interpretation of a statute, was unlikely to be what the legislature would have intended to occur. Nevertheless, this court also noted that no matter what the legislature may have really intended to do, if it did not in fact do it under any reasonable interpretation of the language of the statute, the defect was one that the legislature alone could correct. In other words, as this court held in Valladares, when the language of a statute is plain and unambiguous, courts must apply that language rather than determine what the law should or should not be, speculate as to legislative intent, add something not readily found in the statute, resort to canons of statutory interpretation, or consult legislative history. Therefore, while the state's arguments about legislative intent and the possible effects of interpreting the statute as Terry argues this court should interpret it may be somewhat appealing, those factors don't even come into play in the present case because the plain language of the statute plainly and unambiguously exempts Terry from the statutory definition of the term offender. For the same reason, the Court of Appeals erred in resolving this issue based on a determination that it would be absurd or contrary to legislative intent that an individual could manufacture vast quantities of methamphetamine and sell it to thousands of people but still be exempt from the registration requirements as long as he or she sampled some of his or her products. And Terry agrees that that would be a strange law indeed, but that is in fact the law that the legislature enacted. And under this court's holding in Horn, this court must give effect to the law as written. As written, KSA 22-4902 subsection 11A defines an offender as anyone who manufactures or attempts to manufacture a controlled substance, unless the court makes a finding on the record that the manufacturing or the attempting to manufacture was for such person's personal use. Importantly, the statute does not state that a person is an offender unless he or she manufactures solely for personal use. And that's important, I think, especially given the fact that based on the statute that we're looking at here, the legislature has demonstrated that it knows how to do that. Under subsection E of this same statute, the legislature addressed the fee that offenders must pay when they go to check in with the sheriff when they're ordered to register. In subsection E, the legislature stated that the money collected from those fines shall be used, quote, solely for law enforcement and criminal prosecution purposes. So we know from this very statute that the legislature knows how to use the term solely when it's necessary. It didn't do it in the subsection that the state argues applies to Terry. So I would argue under the plain language of the statute, the legislature has demonstrated that the offender who manufactures at least in part for personal use does not qualify as an offender under the statute. Now, the state argues that such an interpretation is incorrect because the term personal can only refer to a single person. But first, according even to the definitions that the state cites in its brief, personal doesn't necessarily mean a single person. It can also mean private as opposed to public. So to use the state's own example, for instance, a farmer who retains some of his crops to feed his family, I would argue is still retaining those crops for personal use as opposed to public use. And that's true even though they aren't for use for or use by a single person.
Is it just any personal use?
That would
Any
be
personal use. Pablo Escobar, Colombian kingpin, snorts a line of cocaine. He's not he's not subject to registration.
Under the plain language of the statute, Your Honor, I would argue that at least in part he is using those drugs for personal use. And the state, I think, is making the argument that these things are mutually exclusive. Either the drugs are for personal use or they're not, and you can't have it both ways. And I think that that argument might hold true if drugs weren't divisible, if you couldn't break down a quantity of drugs into smaller quantities of drugs. For instance, a toothbrush can either be personal or not. It can't be both. It's either for use by one person, if that is the correct definition of personal, which I wouldn't concede. But if personal means for use by one person, a toothbrush is either for use by one person or it's not. Mutually exclusive. Fine. But drugs can be broken up in a way that a toothbrush cannot be. And I think that's the problem with the state's argument.
And the state's testimony here to show that there was intent to sell as well as personally use involved the trading of the finished product for the pseudoephedrine?
Additionally, that, as well as I believe Michelle Camerlink testified that he did sell to other people. I can check on that, Your Honor, for a citation.
One
if you'd
other
like.
person, I think.
Yes, Your Honor.
Just one other person, I think, was named that he sold to for regular money rather than
trading.
And I understand that you might think that we don't get there, but do you know have any understanding of the legislative history and why this exception was created?
I don't, Your Honor.
Yeah.
And if I'm not mistaken, they have removed.
You're right. And do you have any understanding of why it's been repealed?
I do not. And again, I would argue that because the language of the statute is plain and unambiguous, this court doesn't even need to resort
Right, I understand that would be your position.
To such questions. Of course, even if the court doesn't agree that the language of the statute is clear and unambiguous on this point, it must, at the very least, conclude that it's ambiguous, and in that case, this court would have to apply the rule of lenity and construe the statute strictly in favor of Mr. Mishmash. Finally, under the district court's...
Does the rule of lenity require that we suspend reality? I mean, if it's so clear what the legislature intended, and this obviously is contrary to that intent, do we suspend any common sense in favor of the rule of lenity?
Probably,
and is there any authority that you have for that?
Probably not, but I don't think that this case requires this court to suspend belief in that way, so I don't think this court needs to reach that ultimate question.
Well, you agree that the Court of Appeals evaluation of your position is really possible, that it wouldn't matter how large how many people you were selling to, you wouldn't fall within the statute, which is just the opposite of what the intent was, clearly.
That may be true, but I think the purpose of the rule of lenity is not about what this court derives from the language of a statute. The purpose of the rule of lenity is that people need to know what conduct is prohibited. And here, I would argue that a layperson reading this statute, it doesn't require the suspension of belief. In just reading the statute, that someone might not understand from the language that they would be required to register as an offender. I think looking at the plain language of the statute, they could easily conclude that I am using this for personal use, at least in part, therefore I won't be required to register.
Applying the rationale of Smith versus Doe that these registration systems are a regulatory administrative system and not a criminal punishment, does the rule of lenity even come into this case?
I would argue that there's a fine imposed here, and fines are clearly punishment, historically have been punishment. And although I didn't 609 the U.S. Supreme Court's recent case on that point, I did speak with co-counsel earlier, and she's aware of the holding in Southern Union v. U.S. That's 132 Supreme Court 2344. I'd be happy to 609 that if the court would like, but I think that even if you did classify this as a regulatory scheme and an administrative fee, it's still a fine, and a fine is historically a punishment.
And the fine nature is what?
The fine, I'm sorry.
The fine nature of this is that the registration fee...
The $20 fee, at the very least. And I would argue that the other requirements are a burden, the stigma attached to registering, but at the very least, the fine would require or would constitute punishment, and therefore the rule of lenity would apply.
It's a constraint on one's ability to travel and live wherever they like, isn't it?
Yes, absolutely. And I would point out that the Court of Appeals in Boyer, which I did cite in my brief, explicitly made a finding that the rule of lenity applied to a similar circumstance to the requirements of the Registration Act.
Well, didn't the recent Supreme Court case not really deal with the question of it dealt with the subject matter of fines, but
Yes.
it really dealt with the fact-finding the court made regarding the various multiple violations of a corporation and the maximum of a $10,000 fine imposed for each violation. And the court found those violations. Wasn't that the problem? It wasn't so much, I understand it equated to the fine, but it was the fact-finding that related to the multiple violations.
That was part of the problem, absolutely. That it was a factual question at issue there, and that you have a Sixth Amendment right to a jury trial, and any time that the court is making those findings, that's problematic under the Sixth Amendment. That's
Finding of how many violations of the act led to the imposition of the fine. It was
Yes.
that was the problem, wasn't it?
well, but if a fine weren't punishment, then it wouldn't matter that the court made that finding, is my understanding.
And your complaint here is that we have judicial fact-finding on personal use or not personal use.
Absolutely. Yes. That is the Apprendi argument. And I would argue, just in my remaining time, Your Honors, that the court here, the district court, made an implicit finding that Mr. Mishmash was manufacturing, at least in part, for his own personal use. The district court made a finding that he was not manufacturing solely for personal use, and inherent in that finding is a finding that he was manufacturing, at least in part, for his personal use, and then he was just also manufacturing for some other reason as well. If this court disagrees that that is implicit in the district court's finding, then I would argue that this court must remand to the district court for a finding on that matter, although then I think we would run into an Apprendi problem, so I'm not sure that would be appropriate either. I would therefore respectfully request that this court vacate the portion of the sentence that requires Mr. Mishmash to register as an offender.
We have any questions of counsel? Thank you, counsel.
Thank you, Your Honors.
The state appears by Assistant Solicitor General Natalie Chalmers. The state intends to touch both briefly upon the constitutionality of the statute and then the practical application as it was applied in this case. Turning to the constitutionality of the statute, Apprendi only applies if the district court has to make a fact finding to enhance the statutory maximum. Here, the default position is registration. The special finding or finding that the district court is required to make in this case actually lowers the burden. It doesn't increase. It allows the defendant to avoid registration. So Apprendi simply cannot apply in this case. Turning to the practical application here, the only reasonable and sensible interpretation of the statute is such person's personal use means only for such person's personal use. The idea that the legislator would intend to allow drug manufacturers to avoid registration just because, despite the number of sales that they have, they use their own product is simply unreasonable. I don't know that I have anything else to say. Is there any questions?
But in order to give reason to the actual statute, we have to insert the word solely into the statute. We have to read that into the statute.
I don't think you have to read it into the statute. It's easier if you do. I'll agree that it makes more sense. But I think the words just such persons for personal use, in and of themselves, the only way that they are reasonably construed is only for that person's personal use, not for... I mean, here, he didn't use it for such personal use. He used it to give it to his now ex-girlfriend. He used it to sell it to at least one other person.
Aren't you just agreeing with what Justice Johnson just said? The word only or the word solely. You're saying you need to add that word in to make sense of it. And you do. You do, and that's what the trial court did here. He added the word solely in because
I think he interpreted
that
the
makes sense of it.
phrase. Maybe I'm quibbling nuances here. I think he interpreted the phrase in a reasonable way that, yes, you use the word only or solely, but I don't think you need to add the word. I think the language itself is clear enough.
Well, you just added it in explaining the statute to us.
Right, because explanation is generally you expand upon what is actually said rather than just repeating what's said. But I agree that it would be better if it said only or solely. It would be clear, absolutely. But I don't think...
And if it isn't crystal clear by the actual words there, then why didn't the rule of lenity kick in?
Because the rule of lenity is still, you have to construe the statute in a reasonable and sensible manner, and the only reasonable and sensible interpretation here is then, if it's ambiguous, you use the word solely or you use the word only.
And what is the purpose? What was the purpose of accepting out the personal use?
I assume it's sympathetic for, I don't know the legislative history, but my assumption is some kind of sympathy for drug addicts that are so addicted that they're manufacturing just to use, and they don't see that as much of a danger as if you're giving it to the public.
And so why in the circumstance where you have, assume Mr. Mishmash was basically making for himself, but in order to make for himself he needed the raw materials, so he gave some of the product to get raw materials, and to get the rest of them he sold a little bit so he could continue to buy the materials he needed to manufacture to take care of his addiction. Why wouldn't the interpretation of leaving out solely be reasonable with regard to the purpose of the act in this case?
Because there he's damaging not only himself, but he's actually helping addict multiple other people to methamphetamine. It's not just his own addiction. He's now addicting the person he's trading the pills for and the person he's selling to. Apparently the legislator found some sympathy, I'm not sure why, for manufacturers who are only addicting themselves but not inflicting danger on others.
You understand what I'm saying? You're
do.
saying this is unreasonable within the framework of the legislature's purpose and intent and design for this provision. But in order to make that argument, don't we sort of have to know what the purpose, design, and overall idea was? And I'm not sure we're there. Or I'm not sure I've heard why the interpretation that making for personal use doesn't fit that design.
I would agree that it would have been better if we'd gone back and looked at legislative history and figured out what the actual purpose was. That wasn't done in this case. I'm not even sure that I find legislative history usually unhelpful, so I'm not sure that they would have said or clarified what it was. But I think...
Does the fact that it's been repealed reveal anything about legislative intent?
I think that reveals the intent that they really do not especially want it. I think they're now taking a harsher standpoint, that they don't want the exception, and that means that their intent is pro-registration, and the exception is not going to swallow the entire rule. You wouldn't have an exception every time. It should be a limited exception, and now they don't even want that limited exception. They've completely destroyed it, so that they are pro-registration, not pro-exception, which here, in order, if we construe it that you just...
You say that they don't intend it to swallow the whole rule, which is which is really
exactly
what
would happen if the defendant's interpretation is reasonable. So the legislative, that is another reasonable and sensible interpretation. It would swallow, there would never be registration under this particular statute. Maybe in very, very limited cases.
There's probably people that manufacture that don't use.
Yeah, probably, sure, but I suspect that they are the minority, especially with methamphetamine and as addictive it is.
To allow us to give you the result that you want, what would be the case you would rely upon most?
The Court of Appeals opinion in this case. I'm not sure I have a better case than that. I don't think this issue has been thoroughly vetted in any other court besides the Court of Appeals. I don't think there's any comparable cases that come to mind immediately, other than anything that says that the interpretation has to be reasonable and sensible, and there's no way the legislator intended the exception to swallow the rule.
Counsel?
Can you think of any cases from this court that might aid you in your desire for us to hold in your favor?
No, I don't think so, not off the top of my head, or at least I can't come up with the name of one.
Thank you.
Counsel, you've been asked several questions about legislative intent or apparent purpose anyway. And you've indicated that you think there's been a trend, given the repeal in particular, to treat meth users and manufacturers more harshly. So that implies that there's a punitive purpose.
Oh.
And that hurts you on your it's not punishment argument. So I'd like you to address that disconnect.
Yes, that would be a mistake on my part. I mean, it's the state's continued position that Chambers is correct. The registration main purpose is public safety. Manufacturing meth is a highly, highly dangerous activity. I think everyone can agree on that point. And the public safety, legislators don't want to, I guess, lessen public safety by saying, oh, well, even though you're manufacturing meth, it's for personal use. We don't want, the public safety doesn't matter as much. They've now said the public safety is so much so that they don't want anyone to get out of the manufacturing meth requirement registration.
What was your initial point? I missed it right when you got up. You said Apprende doesn't apply because we're dealing with a lower. Explain that again.
Well, here the default is registration. The district court has to, I mean, in order for Apprende to apply, you have to have an enhancement of a sentence or an increased sentence or for Apprende to apply. I think I say Apprende wrong. But here, there is no such thing. The default is they register unless the court makes an additional finding of some kind. Here, the court didn't make the additional finding. There's no Apprende. I think at best, whether or not this such person's personal use would be an abuse of discretion. Of course, whether or not it's legally wrong then kicks in under the de novo interpretation. So I'm not sure how much of abuse of discretion standard I get, but it's certainly not a constitutional violation.
So it's just a matter of semantics.
Interpretation.
That the case that gave rise to Apprende, if the statute had said the sentence is X, unless the court finds that it's not a hate crime, then it's this. And so that would have been okay.
That would have been okay because it doesn't increase what Apprende kicks in is if they have to make an additional fact finding beyond what the jury made. I think it says maximum sentence a judge may impose solely on the basis of the facts reflected in the jury verdict or admitted by the defendant. If the jury verdict would have allowed that sentence without any additional fact finding by the court, Apprende would not have applied. Here, there's no additional finding. I mean, essentially, if what the defendant wants is right, then none of our statutes are going to stand either because the departure is a similar thing where you say, no, I'm not making finding of substantial and compelling reasons to depart, so there's no departure. That is a negative finding in and of itself. I mean, nothing would stick because as long as there was a way for the court to move the sentence down or lessen the registration, Apprende would always apply, which cannot be the way, I mean, it's not been the way the United States Supreme Court has interpreted Apprende. Even in the fines that they did, it was because the district court had to make an additional fact finding. Here, there is no such additional fact finding.
Any further questions of counsel? Any further presentation?
No, Your Honor. I would just ask that you affirm the registration requirement in this case. Thank you.
Thank you.
Unless the court has further questions, I would waive rebuttal.
How do you respond to her last point? That this really isn't an additional finding to increase the maximum. We start at the maximum. How do you respond to that?
I think that it is a matter of semantics. I think that the district court is required to make a negative finding. The district court would have to find that it wasn't for personal use. So I just think it's a matter of semantics, and that then we could phrase statutes in such a way as to avoid Apprendi problems by just saying that the district court can impose this sentence unless it makes a finding that there aren't any aggravating factors. I don't think that the Supreme Court, it's been so clear in saying that whether or not something is a sentencing factor or an element is just a matter of semantics, and I think this is similar.
But Apprendi's based on, I'm sorry, Justice Breyer, go ahead.
You wanted to go follow up. Go ahead, and then I'll ask my question.
Well, my point is that Apprendi is based upon any imposition of sentence that increases the statutory maximum. This doesn't increase the statutory maximum. You're presupposed under a conviction under this offense to register, and then you present something that shows no, it's for personal use. So how is that an increasing the maximum?
It's an interesting question, and I hadn't really considered it in that light previously. But it's still
isn't your answer that the elements submitted to the jury do not include that the manufacturer be for non-personal use, so that fact is not determined by the jury, regardless of how you phrase it?
That would be my answer. In fact,
I kind of thought.
You're welcome.
Thank you.
My question was just this: to the extent it was purely semantics, doesn't it bear a close relationship to the semantics you're relying upon for your statutory interpretation?
That may be the case, but that's what that's what the interpretation of statute always turns on.
Okay, thanks.
Thank you, Your Honors.
Did you, I'm sorry, you didn't, I don't know if you addressed the point on what impact, if any, the fact that this is no longer on the books?
And I would argue both that puts the state in a tenuous position in regards to issue 1 as far as whether or not the legislature has indicated that it wants to impose harsher punishments or be less forgiving. But I would also argue that indicates a change in the statute. When the legislature changes a statute, it indicates that we're departing from one thing to something new. And so maybe now the legislature is expressing that everyone should have to register, but that just clearly defines that at some point before the legislature intended that some people would not have to register. And I think, as Justice Johnson pointed out, this case is not a case of someone who was selling to hundreds and hundreds of people. I think arguably it was for personal use, even if personal only means for use by one person. I'm not sure what personal use even means, because if he was selling it, isn't that for his own personal use to make a profit? Does personal use mean he has to ingest the drugs himself? So the legislature clearly intended at the time this statute was in effect that some people would not have to register. And I think Mr. Mishmash would fall under that exception no matter how we define personal.
Very good. Any further questions of counsel? Thank you.
Thank you, Your Honor.
Thank you both for your arguments this morning. The court will take this matter under advisement.